Thank you for watching the World Community Magazine's Hour of Power Live on Facebook with your hosts Edward McQueen and April Gardner.
It says live.
It is
live.
time.
Good evening, everybody, and welcome to our program this evening. We're hoping right off the bat that you're going to get something out of this. Of course, you get something out of all of our programs. Tonight, maybe hitting home a little hard. Something that we all got to be thinking of. Of course, my co-host, Ms. April Gardner, welcome. Yeah, I like that. Yeah. So, and she has my favorite glasses on.
Mm-hmm.
Yeah, my favorite glasses on. So again, we're going to welcome our guest this evening. And today, April, we are going to start with the power of attorney. Now, I'm just using that as a theme, but we want to go on from there and move forward with that with our guest, our special guest today, none other than attorney George Graham. And welcome to the program, Attorney Graham.
Thank you. It's an honor to be here tonight.
Good. Glad to hear that. That is an honor. After you get to saying what you got to say tonight, I don't know if some of these our viewers might say when they find out what they have to do with wills and living wills and powers of attorney and estate planning, something you got to do. But we have to do it. And April, you want to fill our audience in on what we can expect today?
Absolutely. Well, first of all, thank you all for joining us tonight. We have Attorney George E. Graham with us this evening, McIver Graham, PA in Conway, South Carolina. And just want to remind all of you that if you have any questions or comments for our guest tonight, you can drop your questions and comments into the thread, and we will moderate those posts throughout the show. Attorney Graham has kind of given us his marching orders, or our marching orders. And so there are 4 specific topics he's going to cover tonight. We're going to talk about the power of attorney, living wills, and estate planning. So as he goes through his topics, you will have the opportunity, of course, to ask questions, and we will field those questions after each topic. And then at the end, we will open it up for even more questions and also further discussion into probate matters. So I don't know about any of you, but I'm excited to learn more because as Brother Edward says, these are things that we don't typically talk about in the Black community, but we need more knowledge of, and we need to make sure we understand, especially when it comes down to protecting the assets and rights of ourselves and our loved ones. And so there's nobody better to do that tonight, and as far as talking about all of this, than Attorney Graham. So welcome, Attorney Graham. It's a pleasure to have you here.
Thank you, ma'am. And as I said earlier, it's an honor to be here.
Absolutely. So I know you wanted to kind of kick it off with the 4 topics, and we're going to take each topic one by one. And so I think you've kind of given me the order of things and how you want to cover it. But can you, before you get started, if you will, just take a moment to kind of put it into context for our viewers as to why it's important for them to understand these legal protections when it comes down to planning.
If for no other reason, our county is inundated with a concept called heirs property. And anytime you have an heirs property situation, the owners of the property ends up getting what's left. Right. First that's paid is the cost. Second that's paid is the lawyer. And the owners who actually earn the property through work or inheritance ends up getting what's left. The topics that I want to discuss tonight has a direct bearing on that situation, not to mention the fact that at least it gives us some idea as to what we ought to do or what we need to do in order to protect the assets that our parents left to us or we leave to our children.
Absolutely.
Mm-hmm, mm-hmm.
Wow.
So as we, take in this information, I think that a lot of people sometimes get caught up in where they should start and what they should think about first. And a lot of times these situations happen because a loved one has gotten sick and they can't speak for themselves anymore, or they have suddenly passed away and their loved ones don't know what to do or how to begin reconciling
Right.
their assets or their estate. So, Attorney Graham, when it comes down to a situation of health matters, I think that's when the power of attorney can come into play. But tell us a little bit more about the purpose of the power of attorney.
Well, let me say, first of all of 4 topics that I'm going to discuss tonight are very, very important. 2 of them take place while you are alive or while the person is alive. The other 2 deals with after the person is gone. The first 2, the power of attorney and the living will, are what we call documents that are effective while one is alive. The wills and of course the estate planning has more to do with what happens after one dies. Okay. Now I'm going to talk about all of them, right? And let's take the power of attorney first. The power of attorney is a document that allows someone else to handle the affairs of a loved one that is incapacitated or cannot do it him or herself. There are basically 3 types of power of attorneys. There's what we call a limited power of attorney that gives one the authority to do limited stuff. Like I could give a friend of mine the power of attorney to sell my house. That's called a limited power of attorney. Then there's a general power of attorney where I could give a friend the authority to do some other stuff other than just sell my house, or to run errands for me, or to pick up my kids from school, various things. And then there's the important one that I call the durable power of attorney. That's the one that one uses when he loses his ability to do things for himself, like
Right.
go to the bank and just general stuff, collect rents. Now, the durable power of attorney has a basis, and that basis is lucidity or not having your good mind. A lot of us will have a loved one who will have a stroke, cannot communicate, cannot talk. Who handles that business? By what authority is that business carried on? The person may be in the hospital, may end up in rehabilitation, and can't do various things like go to the bank, like pay his bills, this, that, and the other thing. The durable power of attorney appoints someone to handle that for that person. Now, all types of power of attorneys are terminated with death. Now, let me say that again, because a lot of folk that I run across or I meet or come in to talk to me says, well, I've got my mama's power of attorney. How long has mom been dead is the question. 10 years and I'm handling the property. That power of attorney is no good. All powers of attorneys terminate upon the death of the person given the power of attorney. So when the person dies, the power of attorney dies. Now, what's the alternative to not having a power of attorney. The alternative is you have to go to the probate court and get conservatorship or guardianship. Believe you me, that's kind of costly. That costs big bucks. So the best thing to do is don't wait for a tragedy to happen. Don't wait for mom to have a stroke. Don't wait for mom to get in an automobile wreck and can't talk. Or don't wait for mom to go into a coma. Go ahead and have mom to do a power of attorney and appoint someone to handle the affairs, at least until she's back on her feet. Okay, that's the first one. Any questions about the power of attorney? And of course, power of attorneys have to be recorded with the court.
Okay.
Yeah, Attorney Graham, I've seen some families, a few where it's just a couple that's there now, but they may put their daughter or their son on their check, as as I guess it's giving them authority to do whatever at the bank.
Yes.
Is that similar to power of attorney?
Well, it's not really a power of attorney. A power of attorney is a document that gives, and the one that I'm talking about is durable, that gives the son or the daughter or anyone that you trust, hopefully is a business-minded person, to do various business activities for you. The bank account is just one aspect of it. It might be you might give someone the power of attorney to bring a lawsuit for you, or to defend a lawsuit for you, or talk to this person or that person, okay? Because you incapacitated and you can't do it yourself or don't desire to do it yourself. Right. So you can, that is a type of an alternative to a power of attorney, but that's just one aspect of it. There are many, many aspects that a power of attorney can cover for a person that's incapacitated.
Attorney Graham, when you said that the power of attorney terminates upon death, is that immediately, or is there like a certain period of time?
That is immediately.
Okay.
When the breath leaves one's body, the power of attorney is now null and void. Mm-hmm. Okay. Mm-hmm. And that's important, because you always get the question, and at least I get a lot of those questions about, well, my brother John has been running everything because mom gave him a power of attorney, and mom has been dead for 10 years. John doesn't have any authority to do anything after mom dies, not based on the power of attorney. Yeah. Okay. And that power of attorney should be durable. And the reason the word durable is in there is because you may lose your lucidity. You may be in a coma. You may been hit in the head from an automobile wreck and not thinking properly. Okay. So because you don't have your good mind doesn't terminate the power of attorney, but death does every time.
Mm-hmm. I know that I think power of attorney matters. And I know you talked about the durable power of attorney, but can you just have a power of attorney that covers only the health decisions of a person and not the finances? Or is it wise to have a power of attorney that covers everything?
The health aspect I'll get to in a minute.
Okay.
But what you want to do is have just one general power of attorney to do everything, and that will not cover health. I'm talking about business matters when I talk about the power of attorney.
Mm-hmm. Okay. All right.
If there are no other questions, let's go now to the second thing that I want to talk about, and that's a living will, which is directly the question that you asked me about healthcare. A living will, also called in a lot of cases, healthcare power of attorney. A living will and a healthcare power of attorney are the same thing. It is a document that directs the doctors, their healthcare providers, and last but certainly not least, the family of the wishes of the person giving the living will or signing the living will. And what does it do? What it does, it tells what the person who has a situation where death is pretty much a foregone conclusion. It tells the doctor, the healthcare workers, and the family what the desires of that person is. What it does is it stops fights, arguments in the ICU waiting room among family members, especially if you come from a big family. If you come from a big family, let's say there are 5 of you, and mom is on the bed, and we think that maybe it's time. Well, the family has to decide, tell the doctor how to deal with these last illness. And if the family don't all agree, say to pull the plug or not pull the plug, there's an argument that takes place among family members in the ICU waiting room. Now let's talk about what the power of what the healthcare power of attorney does, or the living will. What does it do? It's a document that kind of deals with maybe 4 or 5 things. All right. It says, if I'm leaving a healthcare power of attorney or living will, first thing it's going to deal with is organ donation. I want my organs donated. The second thing it deals with is, do I want to be hooked up to a ventilator or a breathing machine? The third thing it deals with is, do I want to be hooked up to a feeding tube? There's a huge difference between a ventilator and a feeding tube. A ventilator helps one to sustain breathing. A ventilator feeds the body with nutrition. And then the third thing, or the fourth thing it deals with is, it can say, I don't want to deal with any of those issues. I'm going to leave Johnny to make that decision based on the circumstances at the time. Keep in mind, it's usually when death is pretty much a foregone conclusion that the healthcare power of attorney steps in and says what I want to happen to me. A lot of older people will tell you, I don't want to be hooked up. I don't want a feeding tube. That's what I don't want. But I'm going to leave that decision up to Johnny, because Johnny can make those decisions based on the circumstances at the time, after consultation with the doctors and after consultation with the family members. I encourage each of you who want or does a power of attorney, please have a conversation with your kids about it so that they will understand, especially if you're going to leave the youngest kid with the authority to make those decisions. In fact, please, let's stop ignoring the fact of death. Let's face it head on. Let's have a conversation about it with our kids and with our loved ones. Of course, no one likes to talk about death. And I like to tell people don't like to talk about death, and the proof is in the pudding. Take a look at what happens at just about every funeral. We'll spend a whole lot of money trying to make the person look like he looked when he was alive.
Yeah.
And what happens to that? it all decays
That's right.
and goes back to the earth.
Mhm.
And now my kids are poor because they've used $10,000-$12,000 to bury me with. Talk to your kids about what you want to happen to you. Now, the big thing about the ventilator and the feeding tube is both of them can back up on you and cause a fixation. Now, people say that, well, let me go home to be with the Lord. That's that person's body, and we ought to honor it. Whatever that person says they want to happen during their last illnesses, we ought to honor it. Because after all, it's not your body. You're not suffering. It's
That's right.
them.
Yeah.
That's what the living will do.
Mm.
Any questions about the living will?
So if a person becomes ill before they have had the opportunity to draft a living will, what can the family do at that point, since the person really can't speak for themselves? And if it's a situation where the person, like you said, loses their lucidity and the comprehension is in question, but someone comes in and says, well, we need to get mama a living will, or we need to get daddy a living will. What can actually happen or can't happen at that point?
What can't happen is mom or dad should not do a living will if they're not in their right mind and do not have their faculties. That is, unfair, inappropriate, and I think illegal. So if you wait too long, right, it's not really mom or dad making the decision. It's the children forcing a signature on mom or dad. And I don't think a lawyer would do that if mom or dad, are not lucid or have their good mind.
Mm-hmm.
What I like to do is I like to ask the person's question. I like to ask questions.
Mm-hmm.
Why don't you want to be hooked up? Or why do you want to be hooked up? And I get answers and I make notes in the file. So if something should come back, right? Basically, we'll know what happened. And I hate to say, I had a client who family voted against the ventilator. I've had a client who tried to unplug the ventilator. You just create all kind of situations that you can't imagine, and you don't want to do that, because your concentration ought to be on comforting and helping the person that's in the bed.
Mm-hmm. There's a question, Attorney Graham, from a member of the audience. Thank you, Bonnie Edie, for tuning in tonight. She asked, if there are two siblings, can both siblings be on a living will?
Yes, both of them can. The parent can leave the decision to both of them. But the thing is, suppose they disagree. You got two people to make a decision. Suppose they disagree.
Mm-mm.
Then
You got the same quagmire if you had no living will at all.
Mm-hmm.
Okay.
And really, the way to fix it, the living will at least will spur some conversation between the person who's making the living will and the persons that are left on the wheel to make the decisions. At least you will know what mom desires or what dad desires. Now, whether you do that or not, that's a different thing. If there's a living will, the doctor is going to follow that directive. The healthcare providers are going to follow that directive.
Mm-hmm. I think that's the part of the conversation that we, as you said earlier, need to have within our families, because you definitely wouldn't want to leave siblings in that kind of a situation And at the same time, I think that the person who requires or needs to have a living will in place has to be firm enough and brave enough to make a decision about who they want to put in charge of their affairs or to handle their affairs, with the understanding of, that their desires are met, but also that, the family just has to work out their issues, because really the living will is the constitution for everything, right?
That is correct. Especially if there are two people that it will be on the living will to make the decision, it needs to be someone that's strong enough emotionally to handle the desires of the person leaving the will. Because the ones that's emotional and I hate to say it because it sounds cold and callous, but the one who can't deal with it emotionally kind of doesn't need to be on the living will. It needs to be the one that's going to be strong emotionally and follow the instructions of mom. Because if mom says, I'm going to put you down, John, to look at the circumstances that are there when and if that time should come, right? Mom is expecting you to follow her desires. And you have to be strong enough to do that. If you're not, it makes no sense for you to be on there. And mom can't make you be on a living will if you do not desire to.
And that's an important point.
Yeah.
That's a very important point. And I think that, because of that point alone, Brother Edward, it's important that people watching this broadcast understand that this conversation just isn't for the offsprings or the siblings to consider. This is really the conversation for everyone as you consider who you're leaving behind to handle your affairs. So,
Absolutely.
hopefully people realize that burden and that responsibility is so great, and you want to make sure that the person you're leaving behind will stand their ground and do what you ask them to do, and also not have any ulterior motives behind anything. They'll do exactly what you want them to do, because there's so many things that happen across not only our culture but all kind of cultures when it comes down to that type of thing. And so that's why the protections are very important, and why you need to know about all these things that Attorney Graham is describing tonight. So
if the parents are in good mind, especially a mom, they know with that innate feeling who is capable of carrying things out.
Of course, they know their kids. They know their brothers and they know their sisters. The other thing that I would note is when mom or dad goes to the hospital, please take the living will with you. Do not leave it perchance and say, I'm in charge, but the living will is at home. That doesn't give the doctor very much latitude with respect to who he listens to regarding the final directives.
Yep. Okay, we're talking about some estate here now.
Actually, we have one. We going into wills, I believe, next.
Yes, the next thing is
on the wills. Okay, all right.
Little difference.
The next thing is, of course, the power of attorney and the living will are considered inter vivos documents, which means those things are in effect or take place while the person is alive. Now, the will is a death document. Please note, the living will is a living document while you're living. The will, as we call it, is a death document.
Well, that sounds cold, man.
A will does not take place, Brother Edward, until someone dies.
Yeah.
Now, A living will deals with final care. A will deals with assets after you're gone.
Right.
Let's talk first about the alternative to a will, and then we'll talk about the will. If one does not have a will, the state of South Carolina tells how that person's assets will be divided. For example, if a man dies and leaves a wife and children, the wife gets half and the children get half. If a man dies and leaves no wife but children, the children get it all. If a man dies and leaves no children but a spouse, the spouse gets it all. If a man dies and leaves no will, no spouse, no children, it goes to the parents. If he leaves no will, no spouse, no children, no parents, it goes to whole blood brothers and sisters. And it keeps going down the line to the next of kin. And if there is no next of kin, it cheats to the state of South Carolina. That's the alternative to not having a will. The state says, the state of South Carolina in this case says, where your assets will go. And if you don't leave anybody, it could ultimately end up going to the state of South Carolina. Okay. Now, that's if you leave no will. What happens if you leave a will? What does a will do? Are there any restrictions on a will? Let's talk about the restrictions first. First of all, you got to be 18 years old to do a will. Second thing, you got to have your good mind. Good mind is defined as you must know who your heirs are or who the bounty of your body is. And secondly, you must have some idea as to what your estate is when you do a will. The big restrictions on a will, and I want everybody to hear this, you can never disinherit your spouse. There's a concept in law called the elective share. Yeah. If you leave your spouse out of the will, the spouse can go to the court where the will is probated, so long as the spouse does it within 90 days and ask the court for what we call an elective share. That elective share is going to amount to a third of the estate. Let me give you an example. Let's suppose that Brother Edward leaves a will and he says, I'm not going to disinherit my wife. I'm going to give her 10% of the cash in the bank. But he has an estate, and the amount of that cash is $100,000. But he has an estate worth $1.4 million. His wife can go to the court and say, I want to get my elective share, which is a third of that $1 million rather than the $10,000 that he tried to leave her. All right. Now, if you don't like dad's new wife, talk to your dad about a prenup or an antenup agreement.
What is an antenup?
And an antenup is nothing. Well, let's talk about a prenup first. Let's suppose that Brother Edward has a second wife and has children by his first wife. Okay. A prenup is a document that's signed before he gets marries the second wife. Prenuptial. before you make those vows. An antenuptial is an agreement that's done after he's married. That usually comes from the pressure involving the children. And daddy, you need to do something because she didn't help you acquire this. My mama did.
Mm.
Right.
And all of those things ought to be talked about freely, honestly, and upfront.
Mm-hmm.
The problem is we don't talk about these issues. And what happens is then Brother Edward's second wife and his kids by the first wife, and he's dead, and they end up hating each other because he didn't have that conversation. Have it willingly, have it openly, and be honest about it. A lot of problems that we create when we try and deal with our assets at the end of life, a lot of them they could just be resolved with a little bit of conversation.
Communication, man. That's always the most important thing.
That is correct.
Mm-hmm.
Now, what are the types of wills?
Mm.
There are basically two types of wills. There's what lawyers call a simple will and what lawyers call a complex will.
Complex will.
A simple will is something brief, short, and to the point. A complex will can be as complex as you so desire. For example, I had a client that gave the quilts on the bed to certain people.
Wow.
That gave the dog to somebody else. Gave the football tickets to somebody else. When we finished with that will was about 50 pages long. That's a complex will.
Mm.
A simple, to the point will that gets rid of your property can be done in about 3 or 4 pages. The other thing that you ought to consider when you're doing a will is what we call the personal representative in South Carolina. The personal representative is the guy or the lady who handles the aspects of the estate, who takes the will to the court and commences the probate. Now, listen, you may have the most caring person on earth taking care of you during your last days, but that may not be the person that you want to take your will to the court and probate it. Please get a business-minded person to handle the job of personal representative of the estate. Okay, just because the person is a caregiver doesn't make him business-minded. And business-minded is because there are duties within the probate of an estate that has to be done that's going to require some business sense.
Mm-hmm.
You don't want someone down there who's just got to rely on the court personnel to help them through the probation of an estate or through a will.
Mm-hmm.
And guys, there's a new item now that you ought to look at putting in your will, especially depending on your age group. That new item, and please write it down and circle it, because you need to talk to the lawyer about it when he does the will. You need to tell whether you want to be cremated or not, or buried under the traditional rituals of the Christian faith. Cremation is a big deal now, especially since the epidemic.
Yeah.
Okay. Now, if you don't want to be cremated, you need to say that. You need to tell the person, the representative. And that's the other thing. When you get your will done, all right, you need to put your will in a safe place, but you need to have a conversation with the personal representative. Where the will is, if it's in your safe deposit box at the bank, right? The personal representative needs to know that. If it's in the wall in the corner of the basement, he needs to know that, or she needs to know that.
Mhm.
In addition to that, always remember when you do a will, you can appoint an alternative personal representative. So if for some reason the original personal representative can't do it or fulfill the obligation, the alternative person can do it. And then the other issue is, depending on who you pick, depending on how business minded that person is, ought to determine whether you require that person to post a bond. If you don't require that person to post a bond and there is money, you better have somebody that you can trust who won't walk away with the money and leave the other heirs out there with no money. Because what happens if there's a bond and the personal representative or representatives get rid of the personal property, the bonding company will step in and reimburse them. And then the bonding company will then go after the people who got rid of the money. Okay. One of the things you can say in the will that I require no bond. But if you say that, please make sure that you've got someone who is honest, above board, and has some business sense. Please. Okay. Now, qualifications. The qualification, the key qualification is anytime you do a will, there can't be any undue influence. Okay. Undue influence is the biggest reasons why wills are contested. Okay. So what you do is, if you take mom to a lawyer to get her will done, excuse yourself. You have no right in there dealing with mom and her affair. Let her mom go in and deal with the lawyer. The lawyer is going to take notes that would indicate whether mom is lucid and has her good mind and good standing and can do a will before he does the will. But if you take mom there, excuse yourself from the conversation, then the other siblings can't ever say that you unduly influence mom to put all of her affairs in your name.
Mhm.
That's mom's choice. That's not your choice.
That's right.
Mom cannot give your property away, but mom can certainly give her assets or property away.
Mhm.
There are two types of property that you ought to be mindful of when you're dealing with wills. The first type of property is real property. The second type of property is personal property. I love it because in law, we define personal property by talking about real property. Real property is real estate. Personal property is anything but real estate. Bank accounts, automobiles, personal effects, those kind of things constitute personal property. But real property is anytime there is land. Now, that brings up a question. How about a mobile home? What is that? A mobile home is personal property. Mobile home has a title. Unless during that lifetime, that mobile home has been detitled or affixed to the land. When I say affixed to the land, you know you can block up a mobile home and put a foundation under it. And if you do that, then that mobile home, you should go to the county and detitle that mobile home, and then that mobile home becomes a part of the land.
That's interesting. That's interesting.
Yes, it is. It really is. Again, conversations we're not having. We assume a lot.
Yeah.
And we think we've handled things just by putting people's names on it or not, or whatever the case is. And don't really understand all of the underlying principles that go along with this. And there's a number of questions here, so I'm going to scroll back up. And these all relate to your conversation, Attorney Graham, about wills. Priscilla Fuller, thank you so much for watching tonight. She asked, can a will supersede the name on the deed?
No. A deed is a living document. Once the deed is filed and it gives the property to Johnny, that property has been dealt with and the will cannot affect it, because the will comes at death.
Okay. All right. Priscilla, if you have any other questions, please post and we'll get right to them. Jamal Kinlaw, thank you so much for watching tonight. Does a will have to be recorded with the clerk of court?
No. At one point in time, the will could be recorded with the probate court, not the clerk of court. In this state, that doesn't happen anymore. You can't even record it with the probate court. And that's an excellent question, because I need to say this, okay? Please note that when you go to the lawyer to get a will done, and that will is notarized and witnessed, the original of that will is given to the person who makes the will. That person ought to take that, and not just the will, the power of attorney, all of it. The power of attorney has to be recorded. But when you get your documents, take them home and either get yourself a safe deposit box, or if you want to save some money, go to the Probate shop and buy yourself a small fireproof safe. Put those documents in the fireproof safe. Okay? I can't tell you how many people who've had a will done and loses the will, or the will disappears. There's a legalism that says if you can't get the will of the testator, the original will, there's a presumption that that will was destroyed by the testator because it was torn up. Nothing could be farther from the truth in a lot of cases. It's because we won't talk to our loved one or the personal representative about where the will is, and they can't find it. And please note, after 10 years, a will cannot be probated. A will is no good in this state after 10 years.
Wow.
Okay, so you got to protect these documents. And I get calls all the time and say, look, I know you were my mom's lawyer. We can't find the will, and my mom died. And I said, wait. Think back, look everywhere, because mom probably did not destroy that will without talking to you. So the will must be around there somewhere. And you can't, the only thing you can do is add legal fees to an already traumatic situation and ask the lawyer to please ask the court to probate a copy of the will. The court will do that if the facts indicate that. But if the facts don't indicate it, where you can overcome the presumption, you don't have a will. So it makes no sense to go through all this stuff I'm talking to you about, and then the will gets lost and you don't have anything to probate.
Attorney Graham, a lot of, I'll say old schoolers, they like to write down their wishes on how things are divided and on a piece of paper and stick it in the Bible. How legit is that particular document?
That document could be very legit if the will says that there's a memorandum that I've written and it's in the Bible. But the only way that piece of paper is going to be good is if it's a holographic will, which means a will in the handwriting of the testator that has to be executed in accordance with the laws of the state of South Carolina. So it may be that if it's been witnessed, if it's been notarized, right? but you may have some problems with that will if it's not done in accordance with the requirements of the state of South Carolina. But if that is a memo that's in the Bible and the will that was made by the lawyer references that memo, date, and where it is, then you would have no problem with that memo being a part of the will.
Okay.
You know, Lawyer Graham, just the other day I had this conversation, and I didn't start it, but someone told me that if a person's name is on an obituary for someone else, does that mean that that person or those people will have an impact on what's left?
Like, are they entitled to something?
Are they entitled to something?
That is an excellent question. And let me tell you why that's an excellent question. And please, audience, just be aware of this. Here's what happens, okay? If I've got 3 kids and a kid that I don't want to say that has taken up at my house, but a kid that I call him a foster kid. He's a kid that I help out, and I die. And my wife says he's got 4 kids, counting the foster kid. Whenever my will is taken to the court, the first thing the court's going to ask 2 things, and I'll get to that in a minute when I start talking about probate. The court's going to ask, first of all, they want a copy of a will if he has one, or they want the will, the original. They're going to want a death certificate, and they're going to want an obituary.
Okay.
Why the obituary? Because people tend to list children or heirs on the obituary. And if he's got 2 biological children and got 3 children, not it say biological, on the obituary it said 3 children. The court's gonna want to know about that 3rd child. So when we do obituaries, I know you want to include everybody,
Right.
but if it's not a biological child and the guy doesn't leave a will, don't list him as a child. Just say a special child or something like that distinguishes him from the biological children, or they can cause some problems for you in the future.
So, but now, what about this quote? This like a half brother or a stepchild. How strong is that?
That's strong. Stepchild, half brother identifies it in the proper way. But if you list him as a child, then there's a question. That's an excellent question. But please keep that in mind when you start putting the obituary. Now, I know that the obituary is a different thing, but sometimes that's all the court has to go by. Especially when you do a probate. Because y'all do know that when you do a probate, it has to be published in the newspaper.
Right.
Yeah.
And when you publish it in the newspaper, there are really 4 things that the reason you publish it in the newspaper. First of all, the newspaper will it runs once a week for 3 weeks, and they will send the court an affidavit of publication. The first thing that publication does, it puts everybody on notice that John died, and it tells who John's lawyer is or who's handling the estate, and it tells who the personal representative is. The next thing it does, it says to the whole world, if John owed you any money, bring the bill to the court and let the personal representative look at it and determine whether they're going to pay the bill or not. The personal representative has that discretion. And sometimes, particularly if the bill is not on the form prescribed by the court, that bill doesn't get paid. The next thing it does, it says, if you owed John any money, bring the money to the court and let the personal representative decide whether he or she will accept that money or not. Of course, he's going to take the money. The next thing it does that most people don't consider is it determines if there are any other children out there that could possibly share in this estate, especially if there's no will. Yeah. And why is that? Why is that so important and so logical? If dad is out there hanky-pankying, guess what dad is not going to do? Come home and make an announcement that I've been hanky-pankying and there's another child out there. Mm-hmm. At one point in time, illegitimate children could not inherit from the father. The Supreme Court changed that in 1976. And what the Supreme Court says, it violates the due process clause or the equal protection clause by not allowing illegitimate children to inherit from the dad. So you got to make a provision for them to do it. Something that plagues our society is illegitimacy. And maybe we'll have a chance to come back and talk about illegitimacy sometime and what the rights are and how that's affected. But we've got a mess. Mm-hmm. The law addresses that, right. But it addresses this, I think, sometimes in a discriminatory way, right? So, but when you publish in a newspaper, if there's a child out there that says, that's my daddy, he ought to come to court and get that established at that point in time. And if he doesn't, as far as the law is concerned, he may never be recognized as a child of the decedent. That's important.
That's deep. That is deep. That's very real. Mm-hmm.
That's deep. That tells me, like in the World Community Magazine, where we publish obituaries in the back, we're gonna have some short obituaries.
Brother Edward.
We're gonna
have shorter obituaries now. People gonna be real careful about mentioning those children of the home and all that other good stuff. Attorney Graham, I'm telling you, this conversation is hot right now. There's a couple more questions, and it's all on the subject of wills, and then we're going to get to probate in just a moment. There's a question from Clarice Hemingway Armistead. She says, you came in late, and I believe you've already answered this, but my question is, if you have only one child, do you still need a will for that child to reap your belongings after death?
I guess the only question I would add is there a husband? If there is a husband, the child gets half, the husband gets half, because you can't disinherit your husband.
Right.
All right. Now, if the child is the only heir, right, you're always going to need a will, because you maybe have to deal with some property that you will have that you don't know you have. That's why I encourage all lawyers to put in a will. And I guess I shouldn't encourage a lawyer. I should encourage all of the listeners, when you get ready to make a will, make sure that there's a residuary clause in there. Leave it to that child. And then if there's a residuary clause, leave that to the child too. And then there's no question that the child gets everything. Okay? But you're going to have the same effect if the child is the only benefactor or the only beneficiary.
I think you've also answered this question. Carolyn Hickman Williams, thank you so much for watching tonight. Would it be wise to give the personal rep and alternative personal rep a copy of the will?
Oh, yes. Yes, please. Have a conversation with the personal rep and have a conversation with the alternative rep. Okay. And the reason you want to have that conversation, first of all, don't give them the original will. Keep the original will in a safe deposit box, fireproof, but tell the personal representatives where it is and what to look for. And you can give them a copy because they're already going to know what's in it and how you deal with it. The other great thing about that, Carolyn, is this: if you can't find the original will and you give a copy to the personal representative, right? The personal representative then has a heck of a lot more credibility when he goes to court and says that the original will we can't find, but the decedent would have told me if they destroyed the will, and here's a copy of the will, and I'm asking the court to probate the copy of the will, as opposed to a benefactor showing up saying this is the will, and let's probate it.
Wow.
So it can get very, very complicated, right? But what you can do is you can ease a lot of the complications by dealing with the issue of death before death comes. Listen, please listen to this. It's not if you're going to die, it's when.
Yeah, that's true.
You're going to die. All of us, as sure as you born, is going to die.
That's right.
Let's face it.
Thing certain. That's the
let's
only
deal
thing.
with it. Let's make it easier for those who we leave. And when I say easier, what I'm talking about is all of you got to know that when you leave loved ones here, they are in a process of grieving. Let them grieve the way they need to grieve and not be worried about all this legal stuff because you didn't do what you needed to do. And
absolutely.
Another question: is the personal representative liable if the estate does not cover all the debt?
No, ma'am. No, ma'am. The personal representative is an officer of the court. The personal representative can be liable if the personal representative does not diligently use the funds to pay any debts or creditors that are out there. Now, what do I mean by that? The law has some priority as to what get paid first. Of course, the court fees get paid first. The second thing to get paid is the funeral bill. We know why. Because the funeral home ain't going to bury you, and you need to be buried if the bill isn't paid. So there's a priority there. Now, what the personal representative ought not do, though, is pay a deal with any other bills until that 8-month period is over that runs in the newspaper. The reason for that is, let's say at the end of the day, the estate has $10,000 worth of assets, or worth of money, and has $20,000 worth of bills. You can't, the personal representative is not obligated to go home to pay those bills. Go to his home and get money to come back and pay those bills. Those bills belong to the dead person. And if the dead person leaves $10,000, then the $10,000 under certain circumstances ought to go to the creditors. But suppose you got 5 creditors, and one creditor got half of the bills, another creditor got 1/4 of the bills, and another one got 1/4 of the bills, and you only got $10,000. If you pay bills off early, you won't be able to do what I'm suggesting that you do. So hold the money until the estate is ready to be closed. When the estate is ready to be closed and you don't have a $10,000 and you owe $20,000, then you break it down based on the percentage of bills. The person represented does that, and he's okay. Now, sometimes the person representative has the obligation to tell the court, I'm not paying that bill. And if he got good reason, he won't have to pay it. Let me tell you the best reason for not paying a bill. The estate doesn't have the money.
Well, do they have to prove it?
Well, they will know it. And I'll get to that when I start talking about probate, because one of the things that happens during probate, the personal representative has to file an inventory and appraisement. So the court knows it. And a lot
And
of
that's
times,
true.
a lot of times you can tell the creditor, I'm not paying it, right? And you won't ever hear from the creditor again. Now, that's not the case all the time, but you can tell the creditor, I'm not going to do it. If the creditor has a bill, let's say, and I don't want to pick on anybody, but let's say American Express has a bill for $2,500, and you send the American Express company who filed a creditor's claim and say, I'm not going to pay that bill. Okay. Now, what's the American Express got to do? Got to come down here, probably hire a lawyer to try and enforce that $2,500 bill. How much you think the lawyer going to charge?
$2,500.
What do you think American Express going to do? Shut up.
That's right.
Okay. That's why one of the reasons you would always want to get a business-minded person to be your personal representative. Okay.
Wow.
Now let's talk about if there are no more questions.
No, I have two more, and I have somebody imploring me to ask you this question.
Okay.
All right. If a wife or husband dies and no will was done, he or she has names on real property and personal property, and the one that is living did not know it, can the other names be revoked legally by the spouse that's living?
Say that again.
Okay. So if a wife or a husband dies and didn't have a will, and he or she has names on real property and personal property that the one living did not know about, can the other names be revoked legally by the spouse that's living? So it sounds like to me the spouse had some property and people's names were on it, and his living spouse did not know that there were names.
He had an interest in the property until later.
So
it depends on how his name is on the deed. If the deed says jointly as joint tenants with rights of survivorship, at the end of the day, that property goes to the survivor of the names listed on the deed. If it doesn't say joint tenants with rights of survivorship, at the end of the day, that's heirs property, and the spouse is entitled to, the spouse and children are entitled to the husband's share of that. I don't care if you got 15 people. They are entitled to that husband's undivided interest.
And that, what is it? Did you say right to survivorship?
Yeah.
That's an important phrase. That's a very important phrase when it comes down to a deed.
It is. And I would, while we're talking about that, I would encourage any long-term marriage that has a house to make sure that your deed is jointly with rights of survivorship.
Rights of survivorship. That's right.
And there are some reasons for me saying that I would be reluctant to talk about in this setting.
You'll need to make an appointment with McIver Graham. Exactly. All right, this is the last question, then we're going to move on.
Yeah, can we remind our audience that this information is free?
Hey, it's free. They better get it all tonight, because it won't be free when they walk through the doors. They better get it tonight. All right. So, how do illegitimate children work? Yeah. How do illegitimate children have to prove that they are the children of the deceased? I think was the question.
Okay. Now we've got DNA, although that's not all inclusive. Okay. For example, if a man dies without a will and he has illegitimate children, the state of South Carolina has a statute that says what that illegitimate child must prove in order to partake in that guy's estate. For example, One of them is that there must have been a ceremony between the mom and the dad, either before or after the birth of the child. That's the first criteria, or the first way. The second way, the dad must have been adjudicated by the family court to be the father of that child, or some other adjudication that he is the father of that child. If not, it is very, very difficult for an illegitimate child to take that way without the members of the man's family looking the other way. Okay, now you see a lot of that, are the consequences of that when you do heirs property. It's just difficult. It's just difficult. Now, the basic reason behind it is this. If mom gets pregnant out of wedlock, mom is going to go back to her community and have the child. Everybody in the community will see that child grow up, go to church, go to school, and who's there? Mom. There's very little time that mom won't spend in public with that child. But dad, it's a different situation. Dad may live in Florida. Dad may have gotten another life and going on. That illegitimate child has rights. And that's why the effort really is, when you talk about illegitimacy, mothers kind of have to take the lead and say, look, you got to protect this child because it's your child. Okay, so there's got to be an affirmative conduct on the part of the mom sometime while that child is growing up to get dad to be adjudicated as the father. Let me give you an example, and I'm not here to offend any Cowboy fans, although I'm a Cleveland Brown fan. The owner of the Dallas Cowboys had a paternity suit instituted against him a month or so ago by a child, or by a woman, not a child, by a woman, saying that he is my father. Okay. Now he filed a response saying, no, I'm not the child's father. And guess what? The other day, that lawsuit was dismissed. What do you think happened?
He's got enough money.
He got enough money to deal with it.
Yeah.
Well, Attorney Graham, I know you could go on and on and on about wills, but you have at least one more topic you wanted to cover tonight, and that's probate. And then we have a question from none other than Jafrania Matrulia Graham, who asked, will maintaining a life estate in property and giving someone the remainder help my family avoid probate? So that's probably a good segue into your discussion.
Yes, it is. And before I talk about probate, let me just say that the topic that I need to talk about is estate planning, and estate planning can eliminate probate. Okay. And what estate planning is nothing but sitting down, talking about and considering, first of all, what you got. List it. What you got. You got personal property and you got real property. If you got a piece of land, with a house on it, all those are different pieces of property. And estate planning is nothing but listing it. Personal property, you got furniture in the house, you got money in the bank, you got the motor vehicle on the outside, you got the camper on the outside. All this is personal property. List it. Put a value on it. Keep a value on it, right? And then what you need to do whenever you do that, have a discussion with your family after you go talk to an estate planner or a lawyer as to how the best way to deal with this. Because a lot of it can be dealt with it before and without probate. Let me give you a classical example. Let's suppose that we have an old lady who has a farmer's home house. And you guys know what farmer's home houses are, right? Where the government subsidized it for a while and mom kept paying on it. Let's say mom has 7 children. And let's say that one of those children stepped in to help mom out. And let's say mom doesn't do anything with that house. And the person that stepped in said, I'm not paying any more taxes, because if I keep paying taxes, I'm not going to get title. What is the best way for mom to deal with that house? Because she's got 0.25 acres of land and a house that she is living in or have been living in for a while. What is the best way for mom? Yeah, here's what mom is going to say. Mom is going to say, Attorney Graham, I want this house left for all the children. What should mom do? What's the best advice for mom? First of all, mom need to talk about it with someone that's not involved with it. If mom came to talk to me, this is what I would tell mom. Do you want to treat your children equally? Mom is going to say, yeah. If she got 7 children, how's she going to treat the children equally with this house? 7 people can't or shouldn't own a house. It shouldn't. Unless while you're planning the estate, mom reserves herself a life estate, which means nobody can put mom off. Nobody can talk or deal with the house or even move in the house while mom is alive. And then when mom dies, mom gives the remainder to the 7 children jointly with rights of survivorship. Now, what does that mean basically? It means this, that when one of the children dies, then the other 6 own it. When another dies, the other 5 own it. And you get on down till you get to the last 2. When the last child, the second to the last child dies, the last survivor owns the house. And guess what you tell mom? This is what you tell her. No one can put anybody off so long as they're alive. But when they die, it goes to the next the people that's living. Who determines and controls death? God. So the last person to live will get the house. And maybe, mom, you can instruct that person by talking to all of them. So if you're the last liver, sell the house and keep the money, or keep the house. We don't talk about it, so we don't ever get there. Okay? Mom dies. You got 7 kids. Okay? You got 7 kids that's trying to fight and fuss over a house. You know what's going to be the big winner? The lawyer. He's going to be a big winner. Unless the kids are astute enough to know what's happening and don't let this turn into heirs property by allowing somebody in that family to buy the others out. Estate planning is about sitting down, listing what you got, putting a value on it, and talk about how you can deal with it prior to your death. And if you deal with it in such a way, you're going to save your family money because they're not going to have to do an estate. You're going to save headache of mom because mom want all of her children to do this, to be here, to have this.
Absolutely.
And that's the way you can do it. Now, I like to tell people all the time, if you can think it, I can write it. In estate planning, you need to be thinking about what it is you're going to do with your assets. Caveat. There's a caveat. And I don't want to sound like I'm talking against living trust or revocable trust and all of that. I just personally think that there's something you can do with property other than put it in a trust. Like, might be the best thing to do to create an LLC and put the property in the LLC and give the family membership interest in the LLC, where they will own a piece of paper that evidence ownership, and the LLC will own the property. And then when that person died, they can give their membership to their family members. Doesn't affect the title to the real estate at all. Won't ever get heirs property. Any other questions?
I don't have any questions, but we do have a comment from Mary Cookie Goins. Thank you so much for watching tonight. She has been here for the entire show, taking it all in. She says, such important information. Thanks, Attorney Graham, for educating us, and Edward April for presenting. And I think that is the sentiment of all of the viewers tonight. This information is just, it's priceless, and it's so critical because Attorney Graham has essentially started the conversation that we're not having within our families.
Yeah, absolutely.
And so now, there are tons of people who are walking away with all this newfound knowledge and some questions that they need to ask their loved ones, especially those who they know are, near end of life. And it's just time to get your affairs in order, really, no matter what the age. If you have something to leave behind, like he says, 18 and up, then it's time to really think about it.
Absolutely.
So Attorney Graham, is there anything else you want to cover tonight? Because you have given us the gamut, and this information.
The only thing that I would like to cover is something that has a direct bearing on heirs property, and that is probate. When someone dies, please go to the court. If the person has a will, take the will to the court. If a person doesn't have a will, take the death certificate, take the obituary to the court, and have his estate probated. The probation is nothing but the process of transferring the assets out of the name of the decedent into his heirs, whether there's a will or there's not a will. If you do that, that eliminates the first phase of heirs property. If you don't do that, you're going to see a lawyer because you're going to need that estate or that property at some point in time, the clouds removed. And if you don't do that, your property is unmarketable. And if it's unmarketable and you cannot get title insurance on it, then the value of it decreases. And ultimately, you're going to need a lawyer to help you clear that up. A probate is very simple. Now, you can do a probate, and primarily, if you are astute enough, you can do everything in there except one thing. And I tell all my clients before I let them go, the thing that you should never play games with doing a probate is the deed of distribution. Because if you don't do the deed of distribution properly, you're going to have to get a lawyer. That's going to cost you money in the long run. Let me give you an example of what I'm talking about. Lawyers don't deal with tax map numbers or PIN numbers. That's for the assessor. And why does the assessor deal with tax map numbers and PIN numbers? Because the assessor use those numbers to charge you taxes on your real estate. That's their ball game. I have seen deeds that's been prepared on the form prescribed by the court. And when it get to the portion that says legal description, I've seen PIN numbers and I've seen tax map numbers. Sometimes the assessor gets the PIN number wrong. And when that occurs, your deed is invalid. Lawyers don't deal with the assessor's office when they're dealing with deeds. They deal with the Register of Deeds office. And what you need to make sure is that you got the correct legal descriptions on that deed of distribution. And if you don't, because you did it yourself and didn't seek a lawyer, it's just a matter of time before you gonna pay some lawyer 2 to 10 times more than you would have paid him had you gone to him and gotten that deed done. When you're dealing with real estate and dealing with a probate, you want to make sure that that deed of distribution has the legal descriptions in it, and it goes to where the will or the statute says it goes. If you're not diligent enough to do that, I'm telling you right now, you have created an heirs property situation or a piece of property that has a cloud on its title. It's just a matter of time before you spend more of your good dollars that you worked so hard for and earn to get a lawyer to clean it up for you.
Well, Brother Edward, yes. This has been an incredible hour and a half. Attorney Graham, I told you an hour, but that's what you get for being so good at what you do. So reputable and so
always a guilty for that.
But this has been an amazing conversation, and we've already had at least one person to say, Bonnie Edie says we need a follow-up show. We're going to have to figure out something else for you to talk about. And you do it so well. Look, you look great on screen.
Thank you.
You really educated us tonight. It's been an incredible time. With you this evening. So you've given the audience a lot of advice. What are your final words? What's the one thing that you definitely want them to walk away with that makes them want to go and start checking their stuff tomorrow?
It is less expensive to deal with it the proper way than to mess it up and have to hire somebody to clean up your mess. My daddy used to say all the time, and what bugs me sometimes is the older I get, the more I hear my daddy talking to me, and I have to say he's right. It is easier and less expensive to do it right the first time than to have somebody come back and clean up your mess.
That's like saying you only pay for quality once.
Exactly right.
And it sounds like while you're above ground, you can only get it right once.
That's right. That's right. I've enjoyed this discussion. I might say you guys are real service to the community, I think. And all of us just need to talk more about what's going on and stop being so quiet about things that are happening around us, and let's assist each other. Those of you who, and there are many of you who've had successful actions in the probate court and in the court in general. We kind of need to share that, y'all. We just do. I mean, keep your confidences to yourself, but there's nothing confidential about procedure. And procedure is the key. Follow the proper procedures and safeguard what you work so diligently and tirelessly to acquire. Protect it with the better part of you. All of you are thinkers. Think about what it is you're doing. Talk about what it is you're doing to your families. And don't create more problems for them. Go ahead and do it right the first time. Because at the end of the day, you guys are going to be all right. Mm-hmm. Thank you so much.
Thank you so much.
Thank you.
Yes. And the best of luck and everything to you, Attorney Graham. Keep doing what you're doing. You're an asset to the community as well.
Thank you.
All right. So, Brother Edward, that was absolutely amazing.
Man, I'm just floored over here.
I am telling you.
I'm just floored over here. I tell you. I mean, we've had some. First of all, let me say this. Again, this was free. All right.
Yes, it was. Free 99. It was free 99 and scrolling across the bottom. Marcus. Yeah, so Marcus, I know you're too young. Well, you think you're too young to think about it, but actually you're never too young to get started. And sometimes I wish I knew then what I know now. And that's probably all the time. So I know you got a lot out of this conversation. And even if you don't believe it applies to you right now, there's great things you can take back to your family. But we're going to share this community announcements real quick. And then we're going to get on with it. I hope you had a chance to have dinner.
I had a little something.
Okay. All right. Well, let's get into it then. What do you have for us tonight?
Well, as you know, there was no city council meeting tonight, but we still have some other news from other council meetings. We're going to start out with the school board. This is one that kind of gets overlooked a lot, but it's very important that we know about what takes place in the school district.
Right.
So there is a penny tax that was instated in 2008 that applies to Horry County schools. It doesn't go towards their day-to-day operations, but to maintenance and building of new schools. So at the meeting on Monday, they talked about reinstating the penny tax due to the fact that they want to build more schools and replace some of the older schools with newer ones. The first thing they want to accomplish is building 2 new elementary schools in the Carolina Forest area. So the biggest thing with that is building an elementary school is not cheap. It costs a lot of money. It's estimated that both of these schools will cost around $50 million a piece.
Ooh.
Right.
A lot of pennies, man. They're going to collect these taxes.
Right. But with the penny tax, they only bring in, on average, $80 million a year off the penny tax. So it might that one penny goes a long way when it's included in everything from tourism to gas to merchandise, retail, all those different things. So it a little bit adds up. Mm-hmm. But along with building those 2 new schools, they would like to replace 2 older elementary schools. They want to replace St. James Elementary and South Conway Elementary.
So are they talking about moving South Conway Elementary or just upgrading the buildings?
Well, that's the issue. See, and included with that $50 million is a purchase for a parcel of land to fit the school because they want to update it in a matter of the way that they did Ten Oaks Elementary School and Palmetto Bays, where they have the all glass fronts. He gives them a more modernized look. Mm-hmm. And the purpose of that is they say it's more conducive to student learning to not be inside all brick with one window in the classroom. They think that it gives the children more of a wide view on life besides just the classroom. They can see other things going on throughout the day as well. Mm-hmm. But another issue they have with the construction is they have to start building on the Whittemore Park Middle School. And that's estimated to cost around $65 million.
The new Whittemore Park.
That's the new school. That's the new school.
Correct. Yeah, the new one. So they want to start building on that before they start building the 2 new schools. Mm-hmm. And that's why they're so adamant about reinstating this penny tax, because it's a part of their policy that they have to reinstate it every 15 years. Mm-hmm. And the first one took place in 2008. So upon the next school term, in December, it'll be time to reinstate it. And everybody at the meeting was, of course, in favor of it because, I mean, it's just more efficient. But the issue was the public input, because a lot of people think that it primarily just affects homeowners. Because you think about that penny tax on the price of a house, it's going to add a lot more, because it's not necessarily just a 1 penny. It's considered to be 1/100th of a total when it comes to buying a home.
Yeah.
So that's adding an extra 1% on a home. Say, for instance, it's a $250,000 home. That's an extra $2,500. So people complain about that, but that's not what that's what they want to make sure people understand, is that it's not just going to affect homeowners. It's not going to affect just people who are building. It's going to be a 1 penny on everything else, in life that you have to buy as far as necessities and other leisure activities and entertainment. But building schools is really important to them. They actually put a fact up. There are 23 schools in the Horry County School District that are in what's considered the red zone. And for those who don't know what the red zone is a school that is at or exceeding the capacity.
You said there are 25 of them.
23.
23, okay.
Which is a dead 50% of all the schools in Horry County.
Are over capacity.
Are at or over capacity. They have met the level or exceeding it in some aspect.
What are their projections, man? Do they project that trend to continue, to start continue exceeding the capacity, or what?
The way that I looked at one of the charts they put out, and the way they see it, they expect numbers in Horry County schools to increase by at least 12 to 15% per year, based upon where they were at 10 years ago. Because of all the people moving into this area, and certain areas of Horry County may not be just tourist areas. Some areas are places where people are starting families in different career fields, things of that nature. And a lot of people can work for these big international and global companies and enterprises from home.
Yeah.
They don't have to go into an office anymore. They can do it from the house. So they can raise their kids in more rural areas of Horry County, in places such as Aner and Loris, Conway. Not be in Myrtle Beach. They can be in Carolina Forest, because that's starting to become a very big business hub for our area. So they're realizing that they don't have to live in Myrtle Beach to be near the beach. And that's a big issue they're facing. They want to make sure people understand the penny tax is going to come into effect soon, hopefully, at the next reinstatement.
All right.
We've got some business news. There is a new Dunk and Go that is located at 2607 Highway 701. For anybody who's not familiar, that's in the North Conway section of town by Homewood Elementary School and the Food Line. And it is the first express Dunkin' Donuts in South Carolina.
Wow, I didn't know that.
Yeah, that is the first express Dunkin' store that stands on its own within the state of South Carolina. And the purpose of it coming was, remember last week in the episode I talked about, they were talking about getting more commerce and tourism and different aspects of that coming into town. And different tax exemptions, other incentives and things of that nature. So they have another exemption and another, I guess you consider, incentive for businesses that come that aren't just hotels or motels. They want to bring more nationwide chains into our area to stimulate the business and growth in other areas of town that aren't as densely populated. And see, they put that the purpose of that was to catch people who were out buying groceries or running errands on that side of town, and also people who are coming into Horry County from the 701 access coming through North Carolina into Myrtle Beach. So they want to do. They hope that stimulates business for the area and is very effective in bringing other large corporations into Conway. Want to see the success of that Dunkin' Go. And as somebody who passes that Dunkin' Go every morning, no matter if it's 9 o'clock in the morning or right before 7 or 7:30, that place is packed.
Wow.
Yeah.
It's really convenient for people who are on that side of town, because they don't have to go all the way into the heart of Conway by Chick-fil-A if they want to stop and grab a coffee.
Right.
And that's what they're trying to do. They're trying to expand the business epicenter of Conway into other sections of town instead of just the 501 corridor.
Is it calling a bottleneck with the traffic?
Not at all. They actually built an access to exit behind the Conway National Bank branch.
That was smart.
Onto Culture Road.
That was smart.
Yeah, they have an entrance and exit coming that back way. And it seems to work very well, because traffic doesn't come to a standstill from people trying to turn in. There's more than one way for them to get in, and they move pretty quick.
Mm-hmm.
So I've seen it in action, and it works very well. And so congrats to the City of Conway Chamber of Commerce on that one. Definitely doing things to help stimulate the growth in our area.
Mm-hmm.
And I've got one last thing. There wasn't a city council meeting, but today there was a special planning and zoning commission meeting at 5:30 that took place about the project I spoke on last week with Healthcare Partners and Dollar General.
Yes. Mm-hmm.
So I did a little more research and made some calls.
Big news, man.
The head engineer that's over that project didn't do his work before time, his due diligence leading into that project. And he totally drew up plans that completely just ignored all of the zoning and code restrictions set by Horry County government and the city of Conway. So now he's having to go back and fix, and they highlighted the packet and everything for him and sent it back to his office on things they have to fix, because like I said, the developer from Dollar General has almost $1 million worth of materials and equipment sitting out there. Waiting to just sitting there waiting. I mean, anybody who drives past that area sees it just sitting over there, just collecting rust, and it's not being able to be put to use. And like the mayor and other city council members spoke on, they want the health care, but they're not going to let a big corporation like Dollar General come in and think they can call the shots, because the decisions they make today will affect the way other companies look at Conway for the next 20, 30 years.
Now, Marcus, let's create some context for people who are viewing tonight who didn't catch you last week. I think it was when you talked about it. So basically, where the Dollar General is now in the old A&P shopping center where Maxway used to be, and the Piggly Wiggly, where the Piggly Wiggly used to be across the street, there are two developments that are trying to happen there, and Marcus is on top of it in terms of the council meetings surrounding these developments. Healthcare Partners wants to take over that entire strip center where the Dollar General is located. Healthcare Partners wants that, but they can't make a move until Dollar General basically firms up their deal to create that Dollar General in the side of the old Piggly Wiggly. Now, the issue is that the Dollar General needs to create a DGX store, which means a store that actually has groceries for residents in the area. And the plans, I believe, as Marcus explained, were not suitable for that particular type of store. And of course, it also impacts the zoning situation with a Dollar General trying to come into that area. And so City Council has asked Dollar General to take a look at their plans so that basically they can bring it up to what is appropriate for the zoning, so that the city of Conway won't create a zoning code that will be too lenient for that particular area. And if it's too lenient, then it will allow other types of businesses that are not best suited for that area to come into that particular parcel and do business or create business based on whatever the zoning is that they decide for Dollar General or the DGX store. So Marcus has given us an update on what's happening, and that's quite an update.
It's a big deal, because like you just said, Miss April, if the deal falls through and things go bad and Dollar General pulls out and doesn't want to leave with Dollar General that side of town, for one, that's a grocery store for a lot of people in that community, because everybody knows that area of Conway is high foot traffic. Most people that live in that neighborhood either have difficulty getting out due to disability or age, or just don't have any other access to a supermarket like a Food Lion or a Walmart unless by public transit or catching a ride. So if they don't have that grocery store, that cuts out all their need, going to the store, going to pick up things last minute for dinner, for one. And for two, if they change that code, it's like you said, they could bring in any kind of business from a bar, a club, something that could be condescended to the neighborhood and to the area, instead of building it up like the city of Conway and all the other entities want to do. And that's just that's their biggest thing. Their biggest thing is they want to help the community, not hurt. Because like they said, when the last storm came, there's no health care on this side of the 501 bridge. Everybody from here all the way back to Ainer had to go all the way to the beach, if it was even possible to access over a major highway like 22. It was more of an inconvenience than it was a help to even get over there. And like those places weren't already crowded as is. So to have healthcare partners have their, clinic here, which is more than just a clinic. I mean, they're going to have all kind of technology and equipment that was donated by County Medical Center and MUSC. If they have that here, that cuts out a lot of need for people to go all the way to County Medical Center for an emergency or to get certain checkups.
So before we go any further, I just want to thank April very much for the narrative and a very good understanding to convey to our audience. That you spell it out very well. Okay, about what was going on and what Marcus was saying himself. I appreciate that. So,
Well, Marcus has done an incredible job as our WCM Live correspondent covering the city and county council meetings. And I mean, think about it, people. This is stuff that we would not really understand or know if we didn't have a correspondent who was actually attending the meetings or, had access to the meetings and could bring it back to us. So I'm merely restating his narrative, which he did a beautiful job explaining it. I think it was last week's show. And so, and again, that's such a fascinating situation that's happening economically in the city of Conway, because that, something needs to be done with that strip center anyway. And to know that healthcare partners wants that. And Marcus explained last week that it's not just the Dollar General piece, it's the that entire block, all the way back around the corner to the old laundromat and, all the way back to the apartment. So there's the possibility that that entire building and that area could be demolished and rebuilt so that those, that facility is even up to code for healthcare partners. And I think you said it was $25 million that they actually
got $25 million tied up in getting all this stuff taken care of.
Yeah, I mean, that could be huge for that stretch right there. With access from, when Piggly Wiggly was there, that was the only grocery store. People from Bucksport everywhere was coming to that particular store. And so imagine from a healthcare standpoint, you have healthcare partners there able to provide that kind of healthcare access. You have the DGX store, which needs to be an up-to-date store, but I believe Dollar General was trying to, I'm going to say it, may have been trying to cut corners so they didn't have to do the up-to-date store. They wanted I think you said it was the bare bones, most basic Dollar General.
They wanted to go to the pretty much the most outdated version that they can still build.
Right. And so they're gonna have to come better than that. They gotta, and I'm kind of glad that City of Conway's holding them to the fire, because where's the fairness in not bringing an up-to-date store anyway? So, but Marcus, do you have anything else for us?
Yeah, I've got one more thing, and I almost let it slip my mind.
Okay.
The county council is having the terms end in December, and most people aren't already campaigning for council members, but most people are already announcing and campaigning for the county council chairman. So that's pretty much the most important seat as far as county government. That's the person that really has all the stronghold on county council. And the two people who have already currently announced and publicized that they're running are Johnny Gardner and Mark Lazarus. Johnny Gardner is the current county council chairman, and Mark Lazarus is a former county council chairman who wants to run again. But people need to realize that when they're running for these offices, you have to make sure you really do understand the candidates well, because sometimes they will try and mix up their business ventures into the political system. And what works best for them and their political partners. So I just want to advise everybody to really do start doing your research now before things start getting covered up and swept under the rug. Do your research now before it becomes extremely public, so you can truly understand what each candidate brings to the table, because this one really affects more than anything else. This is the most direct effect, because what they start at the county level comes down to the municipal level. And it's going to really have an effect, like I said, for at least the next 4 to 6 years.
Know their platforms.
For sure.
Know their platforms.
Yeah, know their platforms and know what businesses they're tied into.
That's right. That's right. Well, I have a few community announcements I'm going to pop onto the screen right now. Just want to remind everybody of some wonderful things that are happening in the area. April 28th. What is that? This Saturday? Is that just Thursday, Saturday? What day is it? 26th, Thursday. From 6 to 8 p.m. Speaker Marion Barrowette, CCU alumna and owner-operator of Bilingual Connections, will be talking on behalf of the South Carolina Latinx Student Summit that's going to be held at Coastal Carolina University. You can register to attend by going to cma.sc.gov. This is a free event. So if you want to learn more about the Latinx community, Miriam is certainly the person who can bridge the gap and help you understand our Latino, Latinx communities, our brothers and sisters in the communities, our brown brothers and sisters. So you might want to check that out. Also, there's a job fair on April 30th from 10 to 1, and this is at Myrtle Beach High School. Summer job fair. So if you have any high school students who are looking for summer jobs, now's the time. They're going to have, I think there are 50 employers who are going to be there, and you can register at myrtlebeachareachamber.com. Also on Saturday, there's a lot of stuff going on Saturday. On Saturday is the Delta Sigma Theta 2022, everything 2022 Community Health Fair, and that's going to be held at Whittemore Park Middle School parking lot. And also, you have the chance to get in on a free fun-filled day, free blood sugar screenings, weight check, you name it, exercise tips, chiropractic care, mental health. They're going to have everything. Over 40 community vendors there. And so you'll want to check them out. Make sure you visit the Delta Sigma Theta Conway Alumni Chapter Facebook page for more information about this particular event. Free registration opens at 9:30 a.m. and that's Saturday, the 30th from 10 to 2. Also happening on Saturday, there's a career fair and business expo at the James R. Frazier Community Center down in Bucksport. That is from 10 to 2 p.m. as well. So if you need more information about that, please call 843-915-5335. Betty Goss, thank you so much for listening tonight, but also for sending us this community announcement for Bucksport. Brother Edward, she must have heard you last week.
That's my sister Betty Goss.
Yeah,
that's Bucksport.
There you go. There you go. Right. And also happening in Bucksport from 10 to 2 during the Career Fair and Business Expo, they're going to have some discussion about a new rain garden. Horry County government is working with the Association for the Betterment of Bucksport, American Rivers, Coastal Carolina University, Furman University, the Coastal Conservation League, there's a bunch of organizations and community partners working together to build a demonstration rain garden utilizing monies from the Butler Conservation Fund. And so you can get more information about this during the Career Fair and Business Expo. They need your input. Come and see the options and share your thoughts at the James R. Frazier Community Center down in Bucksport. That is also Saturday from 10 to 2. So, you can spread your time around, go to the Delta Healthcare, the health fair first, get checked out and all, so make sure you are all good to take on the rest of the day. Then head down to Bucksport. That's right. Then head to Bucksport, see if you need a job or to check on some career options, but also to get in on this rain garden conversation. This is some good stuff, I'm telling you.
Yeah, this is good stuff. Yeah, this is good stuff.
And at some point you might want to head to Myrtle Beach with your high schooler to try and help them find a job for the summer. Wow. And then the Rape Crisis Center serving Horry and Georgetown counties, they're looking for volunteer advocates. And so they're going to have a volunteer advocate training. I believe it's May 9th through the 13th. And if you want more information about that, the contacts are on this flyer. But if you have thought of working in a community service related organization and one that is essential to the needs of persons who are affected by this particular type of the thing that the organization actually serves, the Rape Crisis Center is one that you'll want to contact. So check out the flyer, more information. If you have any questions, Sharon Beatty is the person who can answer the questions for you. And then also Heart for Hearts in Home Care is having a community fair, Conway Strong, on Saturday, May 14th. So mark your calendars. There's plenty of time for this. It starts at 8 a.m. It's going to be on Highway 378 beside Whittemore Park Middle School. And it's a way for you to find out more about Heart for Hearts in home care. They're going to have hiring on the spot. So if you're looking for a job in in-home care, Heart for Hearts is looking for some assistance. They're going to have a yard sale, entertainment, the bouncy houses for the children, free food, and more. Brother Edward, I mean, this is some excellent stuff. And Heart for Hearts is a Black-owned business, by the way. So, yeah, so we definitely want to make sure that we highlight community announcements that are happening in Conway, Bucksport, Myrtle Beach, Burgess, Socastee, all of Horry and Georgetown County. If you have any type of community event information, free events for the public, send your flyers to me so that we can make sure to mention all of this great stuff during our broadcast after Marcus does his announcements for the week. And so that's what I have for the community announcements this week, guys.
Hey, look.
Brother Edward, you kept us on here for 2 hours. It's your fault for getting such a wonderful guest. It was the best 2 hours we spent on any Tuesday night in a long time. That's right.
By the way, I got about 10 more announcements. Is that okay?
Huh?
No.
We'll post them to the website.
Yeah, so look, thankful to our viewers for tuning in tonight. I hope you've really gotten something out of this. I certainly have. April has, and so has Marcus. And thank you, Marcus, for conveying all this important information and making us understand what's right around us. You know, that's important. Okay, we need to know that. So until next week, say Godspeed, and I hope you all will join us next week. We'll always have, well, not always, but we'll try to have a special guest to convey information that is going to help everybody.
Mm-hmm.
You know? So
if you have any topic ideas, anything that you would like for us to cover, and I agree with Bonnie Edie, sometimes we have shows that are so good we have to have a part 2. So if there's anything you want us to research and see if we can bring to you in a special topic, please let us know, and we'd love to do it. All right. Absolutely. So everybody, thank you so much for joining us again tonight. We appreciate it. See you next week.
Godspeed.
Thank you for watching the World Community Magazine's Hour of Power Live on Facebook with your host Edward McQueen and April Garner.